Welcome back, students. This is the conclusion part of the today's lecture, which is on the national, national and international prosecution regarding the international crimes. So, in this part of the lecture, I'm going to discuss what is the applicability of the principle non-retroactivity principle. Students, related to the statutory limitation is the principle of the non-retroactivity of criminal law, which in turn forms part of the legality principle. The question of the compatibility with the non-retroactivity principle arises when a limitation period is extended or set aside retroactively, or when an extraterritorial jurisdiction is introduced retrospectively. National courts have accepted retroactive criminality with respect to the Second World War crimes, insofar as crimes were considered covered by the conventional or customary international law at the time of the offense was committed. Both the Supreme Court of Canada in Finta and the High Court of the Australia in Pulinkovic accepted this regarding the crimes committed abroad. The French Court of the Cassation in Barbec resolved the issue by considering crimes against humanity as a directly applicable international crimes. So states will consider statutory limitation as either substantive or procedural rules, and the principle of the legality is only applicable to the former. But there must, in any case, of the grounds for the concluding that the crimes existed at the time of its commission. Some ICC-related legislation addresses the question of the retroactivity. According to the Canadian Crimes Against Humanity and War Crimes Act 2000, for example, crimes committed outside Canada may be prosecuted retrospectively, but prosecution of the crimes committed before the adoption of the ICC statute is allowed only insofar as the crimes correspond to the state of the customary law at the time of their commission. The Act also clarifies that the crimes defined in the ICC statute are deemed to reflect customary law at the latest when the statute was adopted, possibly earlier, and that crimes against humanity were criminal according to the customary international law or general principle of the law recognized by civilized nations prior to the Nuremberg International Military Tribunal Charter or Tokyo International Military Tribunal Charter. So these are the principles, same as in our domestic laws. The penal laws has always affect retrospectively, not prospectively. It means when there's no crime has been defined prior to the codification of the definition of such crime, it will not affect on the past act. It will affect on the future act. So, but when those tribunal which was created after the First World War or Second World War, they were acted as per the customary international law. So, students, in this regard, the same principle, ne bis in idem or double jeopardy, which is also applicable, and we must acquainted with this principle in our domestic laws. The application between the states, the principle that no one shall be tried or punished more than once for the same offense. It is a general principle. Expressed as in bis in idem or double jeopardy, is reflected in the major human rights treaties and is an expression of the broader principle of the finality and the binding effect of the judgment. The doctrine of res judicata, res sub judice, which we have already studied in being a student of law. But the reasons of the fairness to defendants and the interest of the thorough investigations and preparations of cases by the prosecutorial authorities motivate the principle. The principle also applies in the context of the international cooperation in criminal matters. But these provisions relate only to proceedings in one and the same state. However, it is lawful for a state to prosecute a person for an offense for which he or she has been prosecuted and even punished. Elsewhere, part of this is an outcropping of a principle of sovereign equality. One state's court cannot bind another. It is a rule. Foreign judgments are not binding judgments on the domestic courts, but different states view the effect of the foreign criminal judgment differently. In many common law jurisdictions, for example, the plea of the attributes convict is not restricted to a previous acquittal or conviction in the same domestic jurisdiction. In other states, the practice ranges from almost complete recognition of the foreign judgments to no recognition at all, while most states recognize some foreign judgments to the limited extent. When retrials are allowed, municipal law sometimes demands that a penalty imposed and served abroad is taken into account in sentencing. So, basic differences in a common law and civil law tradition on the issues such as the finality of the judgment, appeals against the acquittal, and determination of the same act influence the application of the principle. While some states apply a narrow interpretation of idiom covering only the conduct in law, other states give it a broader meaning whereby the conduct both in law and in fact is covered. Exceptions may apply, however, and difficult questions arise with respect to the conduct that constitutes multiple offences or continuing offences when interpreting principles. The European Court of Human Rights has arrived at the different conclusions, and the European Court of Justice has accepted that the principle is applied differently by the different European Union members of the states. Further, the next topic, which is the continuation of the same topic, is that the application vice versa international criminal jurisdictions. The establishment of the international criminal jurisdiction adds another dimension to the nimbus in Adam principle in line with their primary jurisdiction vice versa state. The ISTY and the ISTR statute provide that no one may be tried for the same conduct after he or she has been prosecuted at the tribunal, but the tribunals are not hindered by domestic proceedings in certain circumstances. The said criteria relate both the quality of the national proceedings and to the interest of the uh, enjoining the seriousness of the international crimes. Only finalized national proceedings can bar prosecution before the tribunal. The deduction of the sentence principle applies in the event that the tribunal retires the person. The jurisdiction of the ICC, on the other hand, is complementary to that of the states, which calls for a different nimbus in idiom regime. Apart from bearing subsequent ICC proceedings regarding the same factual conduct, conviction and acquittal by the ICC preclude the person being tried by national or another international court for a crime referred in Article 5 that was subject to the conviction or acquittal. Interestingly, surprisingly, it seems that owing to the latter provision, although national courts cannot prosecute a person for an international crime after he or she has been prosecuted for it at the ICC, they would prosecute him or her on the basis of the same conduct for a domestic crime. It may be understandable that states would want to preserve the right to try a person for murder after an unsuccessful war crimes charge at the ICC. For example, when no armed conflict could be established but is worded, the provisions would also allow a subsequent national murder trial in spite of a war crimes conviction on the same facts by the ICC. The ICC statute also provides that national decision concerning conduct also prescribed under the Article 6, 7, and 8 of the statute hinder prospective ICC prosecution. But with certain exceptions, again, shame trials do not bar subsequent international proceedings. There is, however, no exception for cases where the national courts has dealt with the matter as an ordinary crime. It is the underlying facts, not the legal characterization that are decisive. Moreover, the ICC is required to assess whether the national proceedings were conducted independently, impartially, in accordance with the norms of due process recognized by the international law. The ICC statute does not require the court to apply the deduction of the sentence principle, but provides instead for the discretional deduction of the time spent in detention in connection with the conduct underlying the crime. So, students, for the next, our last topic, what are the concluding for discussion is that what are the practical obstacles to the national prosecution? Where national prosecution is of crimes committed abroad, there are special demands relating to the security, logistic, and international cooperation. Some countries have established specialized police and prosecution units to deal with the crimes of this kind. For instance, Canada, Denmark, Netherlands, Norway, and United Kingdom, where international cooperation is required, it may have attendant problems. In many cases, proceedings have been extended due to problems concerning apprehension of the accused. Man was abducted in another state. Barbie was expelled but not extradited from the Bolivia. Tovier was for a long time in hiding in France, and many others have escaped justice because of the extradition requirement. Documentary and physical evidence are normally difficult to secure, and witness evidence is therefore crucial. National prosecution have regularly taken place long after the event. This may make live evidence impossible to obtain or may affect the reliability of the statements made. Key witnesses may have forgotten a critical event and misidentified the accused, as in the Polichovich and Dimension cases. The difficulty of obtaining evidence may also affect fair trial rights, and some national courts have applied rules of evidence more liberally to defense evidence as a protection against unjust convictions. Examples are the Finta case in Canada and the Dimension case in in Israel. Furthermore, all defendants may no longer be fit to stand trial or to serve a prisoner sentence. For example, the Pepun case and the abandoned UK trial against the Simon Sira Finoves. But domestic prosecutions are the backbone of the international criminal law enforcement, since international tribunals cannot undertake prosecution of even a minority of the international crimes. And as such, one of their major functions is to encourage the prosecution at the domestic level. So, students, it means that national domestic or national prosecution is very much and very helpful in order to prosecute the international crimes. So in this regard, I'm also sharing with you, students, a lot of other recommending books and readings, articles, journal articles, court judgments, and also the cases which I have mentioned during my lecture. So I would like to advise you, and I would like to suggest you, if you want to understand the whole system, how international criminal crimes will prosecuted, and what are the practical problems which states are facing. So I will provide you the list of readings. You may gone through those books, readings, writings, and articles, and in order to understand the what are the legality, complexity, and principles, and regarding the national or domestic prosecution. So our next topic, student, is that that will be very because we have, due to the limited time, I will give you thorough understanding of the international prosecution. So after this, after the taking a few minute break, I will continue my this lecture. This is the last topic in next video. Thank you.